Item number 1.
My lord, make a request, my lord. Item number 2, because I've sent for some printout, my lord. Item number 2 is taken up first, my lord.
Pass over.
Well,
Item number 2.
Yes, Mr. Shulai, anybody from state?
In this matter, item 2, no, state is the party.
State is also a party.
Then
I was told Mr. Khan will appear.
I don't have the.
I've served a copy to them yesterday, day before yesterday.
Now, that's item 2. I appear on behalf of the LPSC methods. That is response number 10.
But I just prepared a brief note, my lord, for Lordship's assistance. But this is a review petition, my lord, along with an application for leave for a grant of leave to file a review, my lord. Here, what happened, my lord? If I may just.
Mate, this is your lordship. Lordship, this is a SOP matter, your lordship. Because 2 of my relatives, your lordship, my own cousin, sister, brother, your lordship, are the writ petitioner. So I may not be,
Okay.
lordship, but kindly. Somebody will stand on behalf
But
of
who
the
will,
state, your lordship.
somebody has to be there. Mr. Paul is there on behalf of MPSC.
So I'm sorry, your lordship.
No, it's okay. Because we see, you are the only senior officer of the state who is here.
Mr.
But Mr. Sengupta, does he have the brief with him?
I'll take the notice. Sir, I'll get my lord.
My lord, if I may just.
Yes.
But here, what happened, my lord? The review petitioners, my lord, they are working in sericulture department, my lord. My lord, here the history is like this, my lord. In 2008, there was an advertisement, and these are sponsored candidates, my lord. Through the state government, on the basis of their merit, they were selected to undergo sericulture training, my lord. And after they completed their training, they were appointed in officiating basis. My lord, if I may just take your lordship to the first page, my lord, of my note I have given.
First page of?
Of the note, my lord. I'll cross-refer it with the pleadings, my lord, with the annexures, just to place the facts, my lord. So after completion of the course, these people, my lord, 15 of them, they were appointed on various dates in officiating basis, my lord. On 16/4/2008, 15/9, and till 2014 they are appointed, my lord, 15 of them. Now, my lord, 6 of them, which I've highlighted and underlined, my lord,
Yes.
they came and filed a writ petition before this honorable court, and that was WPC number 493 of 22, my lord. 6 of them. In 22, they filed the writ petition, my lord. And the learned single judge, my lord, I'll just take your lordship to the order passed by this honorable court. Your lordship kindly turns to page 20, my lord.
Page 20.
Page 20 is the order passed by the learned single judge, my lord.
Yes.
Order of 5/9/23, my lord. But I'll take your lordship to the operative model, para 5 at page 21. My lord.
Yes.
Having heard the learned counsel for the parties and noted the submission as also the material on record, it is a fact that a mandamus cannot be issued to direct respondents to regularize the service of the petitioners. However, in the present case, the circumstances are such that the writ petitioners were appointed against vacant sanction posts and were also afforded regular pay scale along with increments, which has all the trappings of regular employment. The case of the petitioners cannot be said to be absolutely without any merit. Also seen the order passed by this court in WPC number 53 of 2019. In that case, however, it is seen that the department had issued a draft advertisement for regularization of service along with approved list for special recruitment to the post of weaving inspector, which on inaction of the respondent, this court on being approached by the petitioner had issued direction for conclusion of the process as per the draft advertisement. Though this case stands on a different footing. However, the fact that this court cannot ignore and has to consider in the terms of the appointment, especially the footnote in the appointment letter dated 18/3/2010, which is similar to the other appointment letters, the same for the sake of convenience is reproduced. Then, my lord, appointment order has been reproduced, my lord. My lord, what is relevant here, my lord, page 24. On the next page, your lord, so kindly see on the right hand side.
Yes.
There is a noting, my lord, in the appointment. You are requested to apply to the Secretary MPSC Shillong as soon as the post of Manager Sericulture Inspector Reeling Foreman is
You're reading page 20.
page 24 on the right hand column, my lord.
24.
My lord.
Yes.
On the right hand column, my lord. You are requested to apply to the Secretary MPSC Shillong as soon as the post of the Manager Sericulture Inspector Reeling Foreman is advertised by MPSC for regularization of your appointment. The present officiating is hereby temporarily unless you apply to the Commissioner and recommended by it for regular appointment to the post. You are liable to be discharged at any time. You are requested to submit it. Anytime you are requested to submit the joining report along with medical fitness. So the condition was, my lord, that those petitioners will have to apply to MPSC for regularization as soon as the advertisement is issued by the MPSC, my lord. And then, my lord, the para 6, my lord. It is noted that the appointment letter itself, the appointee writ petitioner was requested to apply to the Secretary MPSC as soon as the post was advertised for regularization of this appointment. Looking into the situation of the petitioners, there is no doubt they are not possessing any legally enforceable right to seek a regularization to the post, but however, in the considered view of this court, their case deserves some consideration by the respondents in view of the footnote that has appeared in their respective appointment letter. Accordingly, this writ petition is disposed of with the direction that the respondents consider the case of the writ petitioners by looking at the vacancy position in the department and to take steps in accordance with law to consider their regularization. So, my lord, this was the order passed in case of 6 writ petitioners who filed the writ petition in 22, my lord. Now the remaining 9, my lord, I pointed out in the chart, there are 15 persons who were appointed, my lord. Only 6 approached this honorable court at that point of time. Now the remaining 9 have, I represent them, my lord. We have filed another writ petition before this honorable court, and my lord, kindly see the order passed by this honorable court, my lord. My lordship will find that page 294. My lord. 294.
Yes.
But this is order dated 4/11/25. WPC 555. Well, on next page, your lordship can see, my lord. This matter is similar and identical to the facts and circumstances present in WPC number 438 of 2025, wherein this court, on hearing the parties, has ordered that till the next date the service of the writ petition shall not be disturbed and the respondent shall not issue any advertisement against the vacant post. In these circumstances, the same order shall apply. So these are with regard to remaining 9, my lord. But this interim order has been extended, my lord. Kindly see page 296. Now, in the meantime, about 100 writ petitions have been filed, my lord, before this honorable court. All the matters have been clubbed together, and those are listed at page 296. Lordship, kindly see, my lord. Lordship will see interim order passed earlier shall continue until further orders.
Just a moment.
At page 300, my lord. Then, my lord, page 301, the next order, my lord.
Yes. It's 300.
Page 300 is the second order, my lord, making the interim order absolute till, during the pendency of the matter until further orders.
Oh, that is, his 300 is interim order pass and continue.
My lord. And then the next order starts from page 301 and I'll take a lordship to 305, my lord.
Yes.
After hearing at some length, learned Advocate General praised that the state response be allowed to segregate the matter into different categories as per the appointment orders and the regulation orders, and if necessary, a short affidavit will file to address specific situation. He praised that 2 weeks time be allowed, prayer is allowed, list these matters on 4/2/26. Interim order passed early, they continue until further orders. So, my lord, the interim order not to disturb the 9 petitioner service, my lord, and not to advertise those posts is still operating, my lord, by order of this honorable court. Now, my lord, I pointed out in case of 6 writ petitioners, they filed writ petition in 22. There was a direction to.
Say it not to advertise. Which is your opponent should not be disturbed.
My lord, it says, my lord. Kindly see the order.
The you should not be ousted. That is the meaning.
Page 295. Kindly see, my lord. 295. First order, my lord.
Yes.
The instant matter is similar.
Should not.
Not to advertise, my lord. Now, my lord, then what happened, my lord? Those 6 writ petitioners filed a contempt application before this honorable court for non-compliance, my lord. After the contempt application was filed, we are not a party, my lord. These 9 petitioners are not in the picture anywhere in those earlier writ petitions, my lord. When faced with the contempt, my lord, the state filed an appeal before the division bench, my lord. My lord, I'll take a lordship to that order, my lord. Page 216, 216, my lord.
Yes.
Well, may I read this entire order? It's a 2.5 page order, my lord.
Yes.
There is a delay of 768 days in preferring the appeal. The learned Advocate General appearing on behalf of the appellant had submitted that the delay is caused due to an impression sought to be created by the judgment under appeal that the appellant should be required to consider the case of the writ petitioners for regularization in accordance with law. However, the writ petitioners have contended that in fact there is a direction upon the appellants to regularize their service, and on such understanding a contempt petition has been filed and is pending before the learned single judge. In view of the changed circumstance, the appeal could not be preferred earlier. We are satisfied with the explanation offered by the learned Advocate General in not being able to file the appeal within period of limitation. The delay of 768 days in preferring the appeal is hereby condoned. Since no affidavit is called for, all allegations are deemed to have been denied in MCWNO is allowed. The appeal arises out of judgment and order dated 5/9/23 in a writ petition in which 6 persons, writ petitioners, sought a direction for consideration of regularization of the service by the respondents. The learned single judge in paragraph 5 has recorded that on the basis of the material, a mandamus cannot be issued to direct the respondents to regularize the service of the writ petitioner, but directing the state to consider the case on basis of order in WPC number so and so, and also the fact that they were appointed against the vacant sanction post and were also afforded regular pay scale along with increments which had all the trappings of regular employment. The learned single judge also directed the state to consider the order dated 18/3/2010 and the footnote to that said order, which also found place in their letter of appointment in considering the case for regulation in accordance with law. The learned Advocate General has submitted that the said order is now attempted to be construed by the writ petitioners in the contempt petition as a positive direction for regularizing their case with notwithstanding any other criteria that might operate against them in the process of regularization, and in view of that, the writ appeal has been filed. We have been informed that the contempt petition is pending in which the state has filed affidavits to disclose those facts. In our respectful reading of the judgment, it is only a case for consideration of the case of the writ petitioner for regulation in view of some of the facts that have emerged during the hearing of the writ petition and found to be relevant for the purpose of deciding the prayer for regulation of the writ petitioner. We direct the appellants to expedite the process of finalizing and publishing a draft advertisement within 2 weeks from date. Now, my lord, this direction, my lord, in para 7 by the learned single judge to issue an advertisement for those posts held by those. Now, there is no clarity, my lord, whether there is a direction only to advertise 6 posts or all 15 posts, my lord. And unfortunately, my lord, whether it was deliberate or not, the state did not place before this honorable court that 9 petitioners who are similarly situated, my lord. There's a stay order operating in their
But
favor.
then this is by normal assumption. This will apply only to those 6 persons.
No,
other
my lord.
other 9 persons are not a party.
My lord, true, my lord. That's why.
See,
But
other
but
9 persons will be protected by the interim order passed
my lord,
by
the
single bench.
my lord, the advertisement which they issued now, my lord. I'll take your lordship to the advertisement. They advertise all the posts, my lord. My lord, kindly come to page. My lord, before that, my lord, I'll take your lordship to the affidavit.
Will it not, if they have issued this advertisement, and according to you, if it is in violation of the interim order of the single judge, do you not think that this cause of action will lie before the single bench? It is not a case of. Is there anything mentioned in the advertisement that this has been issued on the strength of the order of the division bench?
I'll just take your lordship to the.
Otherwise, you'll be protected by the single bench order. You do not have to. It is the order passed by the division bench is not required to be interfered at your instance, because your order is separate and this order is separate.
My lord, why we have come, my lord? The order passed by this honorable court in 23, my lord. Those were with regard to 6 petitions, my lord. Those were with regard to 6 petitions only. Now 9 writ petitions are before this honorable court. Matter is pending, my lord. And not only that, my lord, about 100 other writ petitions are pending, and all are clubbed together. All are clubbed together now, my lord.
On the all the writ petitions,
My lord,
there are orders passed, isn't it?
there are interim order passed in all
So
the
far as
matters.
this division bench of this division bench order is concerned.
Now, my lord,
In respect of these 6 persons,
my lord,
these 6 persons are not before single judge anymore, isn't it?
they are not, my lord.
Then they will be guided by this. They will be guided by this division bench orders, and others will be guided by single bench orders.
My lord,
What is the problem then?
I'll only take your lordship to the affidavit filed by state in the contempt petition, my lord, because that is slightly relevant. Well, I'll just point that out, my lord. Which?
The state should have pointed out this to the division bench. Even then,
And kindly come to page 30, my lord.
Page
30.
30.
30. So, my lord, this is the affidavit filed by state in the contempt petition, my lord.
Yes.
Now, my lord, I'll take your lordship to para 8, my lord, page 32.
yes.
It is humbly submitted that there are 28 sanction posts for sericulture inspector, reeling foreman, farm manager under directorate of sericulture, so and so. So they say, my lord, there are 28 sanction posts. In para 8, they say, my lord,
Yes.
in para 8, they say, my lord, that it is amply submitted that in compliance with the order of this honorable court, the vacancy position in the department was considered, and at present vacancy position in the department is that as against 14 sanction posts for direct recruitment, no post is vacant for direct recruitment. So, my lord, out of 28 posts, they say 50% is by promotion, my lord, and 50% is by direct recruitment. Lots of questions. Para 8.
What does it mean?
My lord, I'm only trying to point out, my lord, there are 28 posts.
Against 14 section post for direct recruitment, no post is vacant for direct recruitment. That
This paragraph has no meaning, my lord. That's what I'm only trying to point out, your lordship. 28 posts they are admitting, my lord. They are saying 14 are for promotion, 14 are for direct recruitment, my lord.
so right, but then which way take these? That there is no post available for direct recruitment, or there is a post available for direct recruitment?
My lord, they are saying not available, my lord, because all are occupied. And who are occupying, my lord? We are the people who are occupying those posts, my lord.
What he says is that the position the department is that as against 14 section post for direct recruitment, no post is vacant for direct recruitment. So it means this 14 posts are filled up already.
And we are there in the service, my lord.
Oh, so it means that
Then-
there is no- there is-
in fact, those six petitioners and we 9, my lord.
So it means that there is no intention, see, for advertisement of these 14 posts.
My lord, if that was the case, my lord, we had no grievance, my lord.
Because this is what it means.
No, my lord. After filing this affidavit in the contempt proceedings, my lord, state files an appeal. Your lordship has seen the appellate order. The then Chief Justice and lordship was directed to advertise the post, my lord, and they issued the advertisement pursuant to that, my lord. I'll take your lordship to the advertisement, my lord. Advertisement for 14 posts, my lord.
Now, if they themselves say that there is no vacancy for direct recruitment, what is the question of issuing an advertisement there?
They've issued, my lord. After this is, my lord, this is prior to division bench's order, my lord. This affidavit is filed in contempt, my lord.
Yes, yes.
After filing this contempt, where the contempt court was after the state government for non-compliance, my lord, state goes and files an appeal after delay of 700 days, my lord. Then division bench passed an order that you advertise all the
The order of the division bench came after the filing of this
My lord.
affidavit, isn't it?
my lord.
Then,
Now division bench is directed to advertise the post, my lord.
yes, if after assessing the vacancy position, isn't it?
Yes, my lord. Now, lordship, kindly see page 308, my lord. This is the advertisement they issued, my lord, on 19 December.
Three zero eight.
308, my lord.
This division bench order, which you are seeking for review, this paragraph 7,
My lord.
which speaks about the advertisement.
My lord.
This was why this direction was passed. Was there whether a case was placed before the division bench saying that these vacancies needs to be fulfilled on regular basis or something like that? Was it something like that? Why this direction is taken?
My lord, that is may I just complete? May I
Just
just
a
complete? May I just complete? My lord, this was, if I may submit, my lord, just to get rid of the content, my lord, they filed an appeal. And on what basis that order has been passed, my lord, we are not a party in
We
that,
can
my lord.
understand. So whatever it is, but then see,
I have argued, my lord. I can
Just-
advise your lord.
Just a moment, Mr. Kumar. Let us see Mr. Dr. Musika.
So, my lord, how that para 7 was included in that, my lord, that is beyond,
see all the cases before single bench,
my lord.
whether for the 6 petitioners or 9 petitioners,
My lord.
it was basically for regularization, isn't
My
it?
lord, my lord.
Prayer was more or less for
My
regularization.
lord.
The question of issuance of advertisement was
My lord.
not prayed for anyway.
My lord.
Now the division bench has passed this order. Definitely there must be some background basing on which this order has been passed. That is what
My lord.
I didn't know.
My lord, their case, my lord, I heard on YouTube, my lord, the state's case was that through advertisement they'll regularize, my lord.
No, that is what the stipulation made in the appointment order also. That you should apply to the secretary whenever there is a MPSC when the vacancy is there. Okay.
My lord, if that is the case, my lord, if now the first, my lord, appointment order of 2008, 2009, 2010, my lord, we are in 25 now, my lord, 15 years, 17 years down the line, my lord.
We can
State
understand.
never advertised that.
That stands as a different footing. That is so far as the merits of your claim for regularization is concerned.
My lord.
We are concerned with the
My lord.
controversy which has been created by
So, my lord,
different orders.
my lord, situation is that after division bench's order, state has issued an advertisement, page 308, lords, you kindly see, my lord, they have advertised all 14 posts, which in their affidavit before in contempt court, they say all 14 posts are filled up, there are no vacancies. Now they advertise 14 posts, my lord, and we understand are 9 posts, which we are holding.
Dr. Mojika, we do not know. You see, the review of this order, which way this will help the situation, that we do not understand. These 6 persons, as whose instance
My lord,
the single bench order was passed, they are not before this court seeking review.
my lord,
The 9 persons who are not a party to the law is there here.
my lord,
Then the 9 person holds some order in their favor,
my lord,
passed by single judge.
my lord.
So it is very much clear that this order will bind only the 6 persons, nothing else.
My lord, that is clarified.
And
My
if you
purpose is
say
out, my
this
lord.
advertisement violates the advertisement which has been issued violates the single bench order, that gives you a fresh course of action. You take action, then I don't think this calls for any review.
But why it calls for review, my lord? From 2023, when the learned single judge passed this order, my lord, and we are now 2025, my lord, and learned AG is appearing in those matters where about 100 petitions are pending, law has substantially changed, my lord, in our favor. If your lordship permits, I'll place just one or two decisions, my
So
lord.
far as the regulation is concerned.
So far as regulation is
Take us
concerned.
there. Why you are trying to
See,
My lord.
Dr. Musika,
But without going into the matter, our only...
I'm in agreement with my brother
My lord.
to say that you are not remediless. It is not, you see, I think it was not proper for you, or rather it's not proper for you to come by way of a review before this court. Firstly, because okay, if you can make out a very strong case in your favor, we can give you leave to review. But as far as the advertisement is concerned, since there is no specific indication that even the post that you are holding will be advertised, then
My lord, state says that, your lordship may kindly ask the
What is the
state,
advertisement?
page 308, my lord.
Please?
308. They advertise all 14 posts, my lord.
It is sought to be unnecessary.
but there are 28 vacancies, isn't it?
14 vacancies, direct recruitment, only 14 posts, my lord, in the entire department,
For direct recruitment.
my lord.
That position can vary also, isn't it? Or not?
But this is affidavit filed only in 25, my lord. This is filed on
Page 308.
308.
And what is the vacancy shown here?
14, my lord. So all the direct recruitment posts which are held by those 6, in fact 15 posts are held, my lord, but they've advertised 14
But
posts.
then it's okay. See, advertisement, if it is the single bench order, basically bars advertisement,
Yes, my lord.
isn't it?
My lord.
Now, if you say that has been done, that will be in violation of that, and you know what?
My lord, that
you
is
don't
only,
think that review is needed.
my lord, that is only one aspect, my lord. The review, why we have come by review, my lord. I'll just place one order passed by this honorable court division bench, my lord. But when advertisement is issued for the purpose of regularization, my lord, I'll just take your lordship to the last order, my lord. Just point it out.
This order by Apex Court.
No, this honorable court. The last flag, my lord.
Yes. A series of cases.
And this is also series of cases, my lord.
Yes.
But I'm only trying to point out one para in this judgment, my lord, at internal page 12, my lord, of this judgment. There is no para number in this, my lord. Page number is at the bottom, my lord.
Yes.
Internal page 12.
Yes, please do it.
And the para is starting with, my lord, there is no reason why.
Yes.
There is no reason why the respondent should not be regularized. I am minded to grant even further relief to the respondent than given by the learned single judge by directing that in interviews specified in clause would only be confined to factual verification of the identity, date of birth, and for checking of the service records of the respondent without in any way attempting to disqualify her on the basis of any material in the service record, and thereafter to regularize her in accordance with the administrative order of the government. So, my lord, an advertisement which is envisaged under the appointment order, my lord, such advertisement cannot be open advertisement, my lord.
It has to be confined only within this.
Confined, my lord. Just
the parameter
verify the
within-
documents whether they meet or not.
That is a case that is to be made out by you before the single bench, because that matter is yet to be disposed of.
My lord, that matter is yet to be disposed of, my lord. But today, as we stand, my lord, the post held by us have been advertised, my lord.
Anyway, like
That is one aspect, my lord.
what my brother
And the
said-
second aspect, my lord, why review has become necessary, my lord. I'll just try to elaborate on that, my lord. Now the state has this division bench's order, my lord, which definitely they'll place when the matter is taken up before the single judgment.
Others are not a party to this division bench. Division bench judgment will bind only 6 persons. Nobody else. Where is the Christian?
My lord, if your lordship kindly give that much observation, my lord.
That is common. There is law.
My lord may reject my review only with that observation, my lord. This order is only binds 6, my lord.
Can an order be executed against non-party?
They have advertised, my lord, 14 post. These are poor people, my lord.
If they have advertised, you have remedy somewhere else. Not here, not by review. This will complicate the situation more. Because these 6 persons, they are not at all aggrieved. They have not come for review here.
My lord, why the 9 petitioners are in review, my lord? Your lordship kindly see para 7 of the order, my lord.
From Mujika, probably you are before wrong forum. Probably you are before wrong. You see, this division bench order doesn't touch you. Why you are unnecessary making it applicable to you?
My lord, your lordship kindly give that much observation, my lord. I'm only begging, praying for that, my lord. Only with that much observation is not affecting us, my lord. Or state gives a statement before this honorable court that we are not covered in this 14, my
you
lord.
are trying to extend the application of this division bench order to you. When you are
My
not
lord,
a party to
my
it,
lord, kindly see
and you are protected by some other judicial.
My lord, kindly see the vacancy position, my lord. There are only 14 posts they are admitting, my lord.
See, we
All
understand
14 have been advertised,
we
my lord.
understand that situation.
My lord.
We understand. As we have, you see, we will reiterate the same thing, as my brother has pointed out, that your remedy lies elsewhere. See, you could very well approach the single bench and get your relief there, since there's only an interim order passed in your favor. When there's a bar for issuance of any adjustment, and now that the adjustment has been issued, so there is your case. Why are you coming for us?
My lord, that is only one aspect of the matter. The other aspect, my lord, which are more agreed, my lord, the division bench's order, my lord, this is binding on single judge, my lord. This was a larger forum.
Yes, and division bench, as my brother said,
Now they will place this judgment, my lord, the division bench's order, before the learned single judge, saying that government is free to advertise all the posts, my lord. Our case is altogether different, my lord.
By the time we place that advertisement on the close, 23rd January is the last day.
And 23rd January is the last date for advertisement, my lord. Whether we have to apply, we don't have to apply, my lord. We deserve some clarity on this, my lord.
Again, this court is retreating. You have come to wrong. No, there's nothing. You just only need to distinguish this order, nothing else. You are unnecessarily making this order applicable to you.
Well, I am not making, my lord.
This order apply to you. This nowhere mentioned. Number of posts are not mentioned in the division bench thing. If at all, we assume.
In their affidavit, they've said there are only 14 posts, my lord. I pointed that out, my lord.
We have seen even. You do not have to see the order. We have seen the advertisement. It is 14 posts. We take your statement as correct that there exist only 14 posts.
My lord.
Okay. We have no problem. Division bench order is passed only with regard to 6 persons. You are not a party to it. This order, how can it be implemented against you? And especially when you are protected by a single bench order.
Your lordship only.
Now, if this advertisement, if you take your statement as a correct, it goes contrary to the single bench order, and those orders are still in operation. You have remedy somewhere else.
Your lordship gives that much observation, my lord. The remedy is somewhere else, my lord. Your lordship gives that much observation also. Yes, because we have to come to the vacation bench, my lord, because last date is 23rd of January, my lord.
May I submit, my lord?
Yes.
My lord, the issue which is being raised in this review petition on behalf of 9, my lord, is that there is a miscarriage of justice in the sense that there is an error apparent on the face of record in the order, my lord. The jurisdiction of review, my lord, is confined to this aspect of only, my lord. That whether there is no error pointed out by my friend in the judgment and order of division bench calling for the review, my lord, and that too on behalf of 9 persons, my lord. So therefore, this petition itself is not maintainable, and therefore, my lord, if your lordship make any observation, it will prejudice the case of the state before learned single judge, and it will prejudice my case, and it would amount to review, my lord. So therefore, your lordship has, in my humble submission, correctly observed that if my friend has grievance, his remedy lies somewhere else. But that should not come from this honorable court, because It will be open for both state and the private petitioners to argue their matter before learned single judge or before the appellate forum in division against the order. If my friend prefers appeal SLP against the order, we have the remedy, my lord. But if any observation is given, my lord, it will prejudice the case of both the parties, my lord. That is my limited submission, my lord.
See, Mr. Kumar, we need not say the scope of Order 47 is very clear. It is not only on one aspect, that is error apparent on the face of record. Any sufficient reason is also a ground, for which a review can be filed.
Yes, my lord.
That is the scope of Order 47.
I'm not saying
that is on the issue of maintainability. If this court finds that the petitioner have make out a case, then there is no question of of denying their rights. They may be non-party. They may be non-parties for which leave to file review can be allowed. But the only thing is that you also have to understand. You have to understand their plight. They have to espouse their cause before the single bench. That matter is sub judice. Pending. In the meantime, this advertisement has come in the way, and as has been pointed out, there's a deadline of 23rd January. Next time, see, that case is fixed on 4th of February. So you see, then as far as their case is concerned, it would become infructuous if advertisement is allowed to be.
If I submit, what is being challenged before your lordship is the advertisement in the review petition.
Yes.
In the review petition, on the ground that the division bench of this honorable court has directed the state to issue the advertisement. And therefore, what they say is that this gives rise to sufficient cause of action for maintaining review. If I understand correctly, this is their argument that this, because division bench and therefore it calls for review. Now, your lordship has examined two aspects of the matter. First, that what is because the terms of the appointment letter itself said that they will be required to apply for advertisement whenever there will be the process of regularization. That the appointment letter itself said, my lord. There is no doubt about it.
Mr. Kumar, we are not. See, one second. Sorry to interrupt. We are not concerned with all those things. Our problem is with the existence of two contradictory orders. Now, if single bench order has specifically says that no advertisement should be made, was it not required for the state to point out it before the division bench?
I just bring that fact to the notice, my lord. Now, so far as the direction by learned single judge was that the regularized in accordance with law. If your lordship has seen the order of learned
see the interim order which has been pointed out by Dr. Mojika, it specifically says that no advertisement should be issued.
So now I'm coming to the second order, my lord. First order, and there are two orders, your lordship, are one interim order, one final order. Your lordship has seen that one interim order in respect of 9 and one final order in respect of 6, my lord. Now, so far as 6 is concerned, my lord, we have gone against that order before the division bench. The interim order of learned single judge is pending and it is there before the. If there is any violation of that order, my lord, the remedy of my friend is to file a contempt petition against me.
That we have already pointed out. But then
yes, my lord, you have already correctly pointed out. So what my limited submission or endeavor before this division bench is to show that no ground for review is made out, my lord. What is the ground for review? Because the advertisement has been issued in terms of the order of the division bench. Therefore, the order of the division bench should be reviewed, my lord, or recalled or stayed, my lord, in the leave which is being granted in the leave which they are seeking, my lord. Your lordship is currently seized with this limited issue, my lord. It's limited point of, my lord. And so far as the advertisement is concerned, my lord, if they have the issue, they can move the urgent interim application before the learned single judge, and your lordship may hear the matter in the division before the single judge also. But my humble submission is that this is not the remedy which they are trying to seek, my lord. And what my friend is saying that I will place reliance on the division bench order before learned single judge, I am entitled in law to do that, my lord. whether it will apply to 9 or not, it will apply, or whether the interim order will get vacated or not. All these issues are open for learned single judge to examine, or whether in terms of. So my submission is, my lord, that as on today, case of review is not made out or even grant of leave is not made out by 9, my lord. That is my limited submission.
Only prayer, my lord. Kindly protect us, my lord.
I think on that aspect, yes. As far as your review is concerned, since there is no specific indication as far as your case is concerned, I don't think this is a case of review. But see, Mr. Kumar has just given you a hint just now. It is open for you to file you can file an urgent application, get your matter heard by the single bench, and then
My difficulty is only the deadline, my lord. 23rd January. That's the only difficulty.
23rd is what?
Is the last date of advertisement.
Today is
Whether we have to apply or we don't have to apply.
Just a minute. Which your last date has a bearing? If you say that this advertisement is illegal, which your last date has a bearing? Your case will be for quashing the advertisement, isn't it? You want to say this advertisement has been issued in violation of the order of the court.
But the difficulty whether single bench is available
so far as you are concerned. Your concern is the recruitment process, the entire recruitment process.
Not only that, not only that, my lord, not only that, because the second aspect I'm more concerned about is that this division bench is order, my lord, which is without any adjudication on the matter, my lord. Para 7 is without any adjudication.
No, this you are correct one way. This what I do not know subject to what my lord says, but then I also feel that it was proper.
Para 7 is without any adjudication. I'll go to say, my lord, matter was not heard. There is no adjudication, and para 7 has been inserted, my lord. And that is why it requires review, my lord, because that will affect my original writ petition before the learned single judge, my lord. And we are not a party in that, my lord.
No, but then you will be guided by order passed in your case. Other 6.
Well, the difficulty is the division bench order will bind the single judge, my lord.
Other 6 has no grievance with regard to the order passed. Which you,
my lord, we do not know whether other 6 are coming before this honorable court or not, my lord.
Since they have not come, this has to be the necessary interpretation. We cannot say we do not know. That is the interpretation. If they were aggrieved like you, they would have approached this court. They have not.
But my lord, as far as 6 are slightly on different footing, my lord, because there is no interim order in their favor, my lord. We have an interim order in our favor, my lord. It is a very complex situation. I understand, my lord.
Complexity is not there. We are concerned about the basically welfare of the review applicants, nothing else. Otherwise, I don't know. This court is still convinced that the procedure or the remedy adopted by you is not.
My lord, this was because of the vacation going on, my lord.
My lord, if
otherwise,
I may just come in.
because whether can I move a contempt application by urgent application, my lord? My lord, these are the things, my lord.
No, it's not a question of contempt, my lord. If there is a violation of the single judge's order, my lord, we are not here to, as is rightly fallen for my lords, my lord, I can't advise my learned friend, but probably the forum would be something else, my lord, not in a review application before your lordships. That liberty, my lords, can grant my learned friend, my lords, and the matter can be heard before the learned single judge.
My lord, para 7 requires a review, my lord, of the division bench's order, my lord.
True. I think we can comprehend the complexity of the matter in as much as there is some confusion as to whether para 7 would entails issuance of advertisement for all the posts irrespective of the orders passed by the learned single judge, where there is a ban for issuance of advertisement.
Well, learned single judge is because the division bench has not set aside the learned single judge's order, my lord.
True. That is where as my brother has pointed out, that is where the state fails to bring before the division bench these facts.
These facts, my lord. And that is in my humble submission
That has complicated
sufficient
the
reason for interference or for review, my lord. Do you apply or not apply? We don't know.
If I may, Milad,
Yes,
there is one more difficulty. Milad, there is an application seeking leave. Now, even if my lords were to grant leave, Milad, before granting leave, your lordships would have to first issue notice to the respondents in the main
we understand.
appeal.
Yeah.
That's going to frustrate the entire case of
understand.
the review petitioners, if at all, Milad.
You see, even if we grant leave, the review
Well,
petition is yet to be admitted.
Absolutely, Milad. And lordships cannot grant leave. What I'm submitting before your lordships is lordships will not grant leave without my lord's service upon the respondents in the main appeal, because they are not before your lordships.
We have
So there
already
would
served.
be some
We have served, my
difficulty,
lord.
Milad.
They chose no to appear. We have served a copy.
Have you filed any affidavit of service?
It is in the notice, my lord. We have served on the council. Or
If it is served, then there is no difficulty.
Have to file reply to the application, my lord. We will file reply to the application also, my lord.
Honestly, I was
Because-
waiting for that points to be raised. By point Mr. Paul has raised, I was waiting for that points to be raised. Even if it is leave it to them, we have to issue notice and then only thereafter.
It would not serve my learned friend's case, Milad. I understand there is a
my
predicament.
lord, leave primarily is between court and the petitioner, my lord.
So, but then their party, can we do it without?
No, we are necessary party, my lord. We have to be heard on whether grant.
No, state has already been
granted or
served.
not.
State is represented. State.
State
Service have to file reply notice if go if they want.
No, state is how
But
state
that
is
is
siding
no-
with those 6 writ petitions, my lord. I don't know.
First, the notice has to go on the issue of leave.
My lord, these
If at
technicalities,
all.
I know, my lord, the state only has a technicality in their defense, my lord. But kindly look at the merit of the case. my lord.
Everything on merit also. We are not going into the merit, but that is not the issue. Merit, we have got good point on merit also. If we,
My lords, my
and that is
humble
what we
submission
always-
is, my lords, if my lords have a look at the order of
And Mr.
9,
Paul is only
12,
representing
even
MPSC,
5.
my lord. Mr. Paul is only
My
representing
lords, I'm
MPSC.
representing MPSC, which is why we have issued the advertisement. 9, 12, if your lordships kindly look, para 7 would have to be read in conjunction with para 6. Para 6, if my lords kindly have a look at page 219. There's a prima facie view that the division bench has taken, my lords, on this matter. If my lords have page 219,
yes.
my lords, third line, second line, in our respectful reading of the judgment, it is only a case for consideration of the case of the writ petitioners for regularization in view of some facts that have emerged during the hearing of the writ petition and found to be relevant for the purposes of deciding the prayer of regularization of the writ petitioner. In other words, my lords, if my humble submission would be, it is only a case for consideration. The important word would be consideration here.
Mr. Paul,
Which is why, my lords, then in the second paragraph at para 7, the division bench then says that we direct the appellants to expedite the process of finalizing and publishing a draft advertisement within 2 weeks from date. So it's not the case, my lords, that where there is a positive direction for, my lords, regularizing the writ petitioners. It says, my lords, that it is only a case for consideration,
No,
which is why, my lords, the advertisement then comes in.
I think there's no quarrel there.
My lords.
see, Mr.
So,
Paul,
therefore, my lords,
see, Mr. Paul, Mr.
therefore, my
Paul,
lords,
see, writ
My-
petitioners are not here. Okay.
Absolutely, my lords, which is why-
paragraph 6 confines only the writ petitioners. That means those 6 persons.
absolutely, my
Yeah,
lords.
so this 9%
So
should not
there-
be bound by this order.
Absolutely, my lords, that's what I'm trying to point out.
My lord, if that is recorded, Mr. Paul's
My
submission, my
humble
lord,
understanding of
that
this order is
we
that
are not covered under this advertisement, my lord. My lord, kindly record that statement.
Can there be any controversy with regard to that? Just say normal for a decree of a civil court. Can it be executed against a non-party? Can an order be executed against a non-party? The answer lies there.
Kindly look at the advertisement, my lord. They admit there are only 14 posts, my lord, and they advertise all 14 posts, my lord.
That is where right from the beginning we have indicated that he have chose the wrong forum.
My lord, forum, my lord, because of the vacations going on, my lord.
No, there's no stopping you to file a proper application.
My lord,
Get it
we will
listed
file a
before-
contempt, my lord.
I think the clue is falling
Contempt
for my lords.
in a contempt. Can we ask for a stay in contempt proceedings, my lord? That's
No, we are not on. We are,
My IE also, my lord,
This is not a question
listing
of-
rate petition.
My lords,
is
my
not a-
learned friend is well equipped to know, my lords, that there are other avenues.
my lord. I am before your lordship. Look, kindly protect me either way, my lord. Whichever way your lordship feel it fit and proper, my lord. Kindly protect. Because they are poor people, my lord, and this will seriously prejudice their case. Whether we apply against by 23rd or we don't apply, my lord.
even if we want to protect you,
My lord, whether, my lord, kindly,
on what
if they can
basis-
answer one question, my lord,
you tell-
whether we are
you tell
required to
us.
apply against this or we are not required to
you
apply.
tell us on what basis can we pass a stay order under the circumstances.
My lord, the stay order only on the
Even
ground that para
technically-
7 of the order is
Even
without
tec-
any adjudication. my
Even
lord.
technically, the other 6 respondents that you have read here has to be issued notice. You said they have received notice. No affidavit of service has been filed. That's number 1. Number 2, when the matter is far removed from what you have, your grief with, I don't think this is filing of passing of a stay order. We can give you help us and to find a way to.
Well, kindly protect some way, my lord. But I'm not asking for a stay. I'm not asking for review. Kindly protect us, my lord. This 9 writ petitions are only an observation that we are not covered because of the stay order, my lord. Either way, my lord. I'm just praying that, my lord. Or else whether we apply against this advertisement or not, my lord. 23rd advertisement will close.
These 6 persons or 9 persons are represented by 2 different sets of lawyers.
Mr. Philemon Nongole is appealing.
So that has caused another.
It damaged our case, my lord. And law is so much changed, my lord, in the last 2 years. There's a mandamus issued now, my lord. So I have given the comparison if the lordship permits me. I'll take a lordship to 2 or 3 judgments.
Umadevi is not.
Umadevi has been clarified, my lord, in these judgments. That if
If clarified, there are decisions. See,
my lord, these are the 25 decisions, my lord.
okay, but then at the same time there are decisions which says the larger man's decision has to be respected.
My lord,
That is the
my lord,
problem
they've
is
clarified what Umadevi's
that-
intention is.
Anyway, we are not going into all those questions.
The lordship will desire, I can place, because now our case is for a mandamus, my lord. 2022, those judgments were not available, my lord. That's why the learned single judge directed for.
Umadevi has still stands. It has not been recalled still. So that is why.
Umadevi is clarified, my lord. State cannot violate Umadevi, my lord, and then seek protection of Umadevi. That's what Supreme Court said, my lord.
Exactly. You are correct.
State violated Umadevi, my
That
lord.
is anyway. The
The
context
state has not violated Umadevi. State has not violated Umadevi. What my friend is saying.
Any respondents, if they violate Umadevi, my lord, or maybe union or state or district council, my lord, they cannot take protection of Umadevi, my lord.
My friend is seeking leave to review, my lord.
My lord, why did not state inform the division bench, my lord, that there are interim orders operating by this honorable court, my lord?
Issue before division bench, what I should inform and what I should
Same
not
department,
inform
my
is not. The issue is that issue before the division bench was that whether the direction of learned single judge and contempt proceeding, and in that context the order was passed. Now, if I have to go back, I will go back to the learned single judge and point out that what is how the division bench order is binding on learned single judge or not binding, or it requires to be reconsidered.
We've heard the parties. We've heard the parties. We'll pass and see orders.
Obliged.
Second call, item number 1.
This is a tender matter, my lord. We have come against the interim order passed by the learned single judge, my lord. Your lordship will find that order at page 459, my lord. 459, the last page.
Yes.
The operative part is para 3, my lord, on the next page. May I read, my lord? This court has considered the submissions made by the learned counsel for the parties. It is seen that matter is urgent in nature as it concerns the roofing seats which are meant for the below poverty line population. However, as the matter deserves further consideration, especially in view of the division bench order of this court, it is directed that till next date, 25% of the said work order shall not be settled with any party. So, my lord, there is a restraining order restraining the state from settling the 25% of the contract, my lord. And the matter is fixed on 4th of February. Now, my lord, this order has been passed, my lord. Primarily, our grievance is this order has again been passed when the order of the division bench was not properly placed and appreciated by the learned single judge, my lord. I'll just take your lordship to the division bench order, my lord. Page 3.
Page 64.
This matter is coming up on 4th February again. What is the need? This is under litigation from 2024 onwards. Maybe urgent, but then it's okay. Wait for that. It's only interim order, very limited scope of interference.
That's true, my lord. But only because, my lord, I'll just only place the division bench's order, my lord. Whether the writ petition could have been entertained, my lord, in these facts, my lord.
Page 69.
My lord, page 445, my lord. There is an order passed by the division bench of this honorable court.
Yes.
445, my lord. My lord, this is, sorry. This is an order.
Yes, please.
Please.
This is an order passed by this honorable court on an application filed by Meghalaya Roofing, lordship, kindly see, my lord. And after this order was passed, Meghalaya Roofing again filed a writ petition before this honorable
You are
court.
not Meghalaya Roofing, you are
We are Power Roofing, my lord. Now, my lord, this order,
Meghalaya Roofing is Mr. Sangaisha.
yes, my lord.
Who has got 75? You've got 75.
I've got 75%.
Okay. So you.
I'm expecting another 25%, my
so
lord, being in the
apart from
L1
this
bidder, my lord.
75, you're expecting.
My lord.
But that is for the tender committee to decide.
Yes, my lord, I'll just place. There are few aspects, my lord. My lord, before that, if I may just point out the facts, my lord, then it will be easier for your lordship to appreciate things. Okay. Give to them also. But this was a tender issued on 10/9/24, my lord. NIT issued by Director of Housing for supply of aluminium roofing sheets for below poverty line, but they supply from government scheme, my lord. 4 bidders participated in the bid, my lord, originally. Power Roofing, Manakshiya Limited, Meghalaya Roofing, and Mariam Commerce, my lord. Now, at the technical evaluation, my lord, Manakshiya Limited was disqualified, my lord. And Mariam Commerce also was disqualified, my lord. So only Power Roofing, my client, and Mr. Sangresa's client, they're technically qualified, my lord. So their financial bids were opened. Both of us, we quoted same price, my lord. So what government decided, looking at turnover and other factors, my lord, the government awarded us 75% of the contract, my lord, and awarded Mr. Sangresa's client 25% of the work. Now, my lord, after this work was awarded and before we could even commence the supply, my lord, maybe small quantity was supplied, Manakshiya Limited and Mariam Commerce, who were technically disqualified, approached this honorable court, my lord, challenging their disqualification. Now, this learned single judge of this honorable court, my lord, set aside the entire tender process and asked for re-tendering, my lord. If I may take your lordship to that order, my lord, page 387, my lord.
Yes.
It starts from 387, my lord, the operative part, if I may just. Page 429, my lord. Page 429, para 46.
Yes.
Accordingly, for the reasons aforementioned, the entire tender process pursuant to the NIQ dated 10/9/24 is hereby set aside. The consequential work order issued to the respondent number 4 and 5 therefore shall accordingly be also stand cancelled. However, keeping in mind that the matter concerns the providing free roofing sheets to below poverty line families, which is vital to their shelter and well-being and in the greater public interest, the state respondents are directed to immediately float a fresh NIQ, citing clear and unambiguous requirements in the terms and conditions. So basically, the NIQ was set aside, my lord. Then we, Power Roofing, my lord, we prefer an appeal before this honorable court, my lord. That order your lordship will find at page 432, my lord.
Yes.
But now, my lord, but here, my lord, this honorable court division bench held, my lord. If I may just again. Page 437, my lord. These paragraphs are not numbered here.
Yes.
The last paragraph, 437. The question which arose while hearing these appeals was that the learned single judge was considering writ writs preferred by two intending tenders. We say intending because their tenders had not even been admitted at the threshold for consideration by the tender committee on the ground of technical ineligibility. Now a party who has not entered the tender consideration process was allowed to maintain a writ challenging inter alia the decision-making process after a formal consideration and acceptance of tender by the decision-making authority. According to us, the eligibility criteria of those two tenders, namely Malaxia Aluminium and Mariam Commerce Limited, should have been the first issue to be considered before going into anything else. We appreciate the wisdom of the learned counsel in appreciating the point and aiding us to dispose of these appeals. We think that the tender process should be thrown wide open. The eligibility of Manaxi Aluminium Company Limited and Mariam Commerce Limited be considered afresh by the tender committee by giving them a short hearing and by reasoned order within 4 weeks from date. We make it clear that non-availability of MIPP certificate shall not be a ground for technical disqualification, and we also make it clear that the technical eligibility of Power Roofing and Messrs. Meghalaya Roofing found to be eligible during the subject matter tender process shall not be reopened or revisited. Thereafter, the tender committee will proceed to process and consider the tenders in accordance with law and tender terms and conditions. The subject tender process is not annulled, but same shall continue in the manner indicated above. So, this Honorable Court Division Bench directed to give an opportunity of hearing to those two who were technically disqualified. Thereafter, the government.
That means that it's virtually interfered with the single bench.
Learned single is set aside, the division bench said then you go ahead with the same.
This revives tender process again.
Revives tender process. Now, in terms of that, the government of Meghalaya gave opportunity of hearing to Manaxia and Mariam Commerce. Now, Manaxia appeared for the hearing, Mariam Commerce, they did not even appear for the hearing. And the tender committee again held that they are technically not qualified, And thereafter, in the meantime, what is more crucial here, because for submitting tender, they have to give EMD deposit, Now, Meghalaya Roofing, Mr. Sangresa's client, after the learned single judge's order setting aside or quashing the NIT proceedings, they also filed an appeal against that order, before the division bench, but they never disclosed that they have withdrawn the EMD from the department, The crux of the matter is withdrawal of EMD, So, after the division bench passed this order, they came and filed a miscase before this Honorable Court, page 445, kindly see.
Page 45.
445. May I read now?
Yes.
Page 445.
Please.
The applicant is one of the successful tenderers. This application has been filed for clarification of the order passed by the coordinate bench on 28/8/25, by which the tender process was thrown open and the ineligibility of two tenders held to be technically ineligible required to be considered afresh by a tender committee by giving a short hearing and by reasoned order within 4 weeks of the date of the said order. Insofar as the present application is concerned, it has been clearly stated in the said order that non-availability of MIPP certificates shall not be ground for technical disqualification, and the technical eligibility of Power Roofing and Meghalaya Roofing, the present applicant, found to be eligible during the subject tender process, shall not be reopened or revisited. The tender committee shall proceed to process and consider the tenders in accordance with law and tender terms and conditions. The applicant preempted that the tender committee, in furtherance of the order and in implementing the said order, may not take the EMD already deposited, which is one of the vital technical criteria, and in the event it is not accepted, the applicant may be declared ineligible and its offer may be rejected on the ground of technical ineligibility. This cannot be a ground for any clarification of the order, as the order in our opinion is clear, and in terms we cannot at this stage preempt that any arbitrary action of the tender committee, as the order clearly states that the tender committee shall process and consider the tenders in accordance with law and tender terms and conditions. The apprehension appears to be misplaced, as the tender committee was directed to act in accordance with law and cannot deviate from the terms and conditions of the tender. If the tender committee acts arbitrarily, it may give rise to fresh cause of action. Moreover, the present application was benefited by the observation made by the coordinate bench presided over by the then Chief Justice that non-availability MIPP certificate shall not be a ground for. So, my lord, what I am stressing on this is, my lord, the sentence that if the tender committee acts arbitrarily, it may give rise to a fresh cause of action. So, my lord, after compliance with the division bench's order, my lord, those two technically ineligible were again declared ineligible, my lord. So, we are only two in the fray, my lord. They have withdrawn their EMD, my lord. Now, tender committee, after in the second round, my lord, again awarded 75% of work to us. We have executed the 75%, my lord. Now, 25%, whether that EMD which they have withdrawn, whether they can still claim the contract or not, is to be decided by the tender committee, my lord. And this honorable court division bench held, if there is arbitrary decision, that will be give a fresh cause of action to them, to Mr. Sangreso's client, to challenge before this honorable court. Now, my lord, that 25% decision has not yet been taken by the department, my lord. In the meantime, even before the cause of action arises in terms of this division bench order, my lord, Mr. Sangreso's client files a writ petition before this honorable court, my lord, and that is the stay order passed by this honorable court. So, my lord, our case is, my lord, let the tender committee decide whether they are, and if they are agreed by the decision of the tender committee, if they disqualify them or declare them no because you have withdrawn your EMD, we cannot give you the work, then they can come before this honorable court, my lord. At this stage, when this honorable court division bench held that let tender committee decide the matter, if they are aggrieved, that will give rise to a fresh cause of action, then they can come and challenge before this honorable court. If that is not, the cause of action is not a reason, my lord, and they filed a writ petition and the learned single judges stayed the entire thing, my lord, not to award the contract 25% to anyone.
Even then, you see, Mr. Dr. Musika, as my brother has pointed out, you could have very well agitated the matter before the learned single judge, because the writ petition was not finally disposed of.
It's not been disposed.
You could have still made out a case in your favor and get the final order passed. It could be, we are not saying so. It could be that the learned single judge may fall in line with your line of argument or not. Even so, even otherwise, either of the parties still have a remedy. Now, at this point of time, to come against an interim order, I don't think it's proper.
In addition to what my lordship has pointed out, I ask you which way this order hampers you. You said that tender committee has not taken any decision. Then which way you are aggrieved at this?
But I am agreed if tender committee may take a decision in his favor, or if it is against him, that work will come to me, my lord.
Till now, it has not taken any decision. So you do not have any cause to feel aggrieved at this stage.
Well, I have a legitimate expectation, my lord.
That is
Because they have withdrawn the EMD.
Expectancy also is not bad. It is only a temporary protection.
It is a temporary protection.
And then temporary protection doesn't disturb your existing right now. You do not have any right so far as 25% is concerned in existence at this stage. Definite right. You have only expectancy.
Only
That
expectation.
let it be decided by the single judge.
You have suppose this could premature.
I'll withdraw them.
That is better.
By coming for this court, you are giving a bonus to Mr.
Because any observation may prejudice me
Sir,
before the
getting a
single
bonus.
judge.
The state is filing the case, but my attorney is avoiding filing it before the single case.
Dr. N. Musika, senior counsel, appearing for the appellant, has at the outset made a prayer that this matter may be allowed to be withdrawn. Accordingly, as prayed for, that is dismissed as withdrawn.
He is too protective, you see, he wants too much protection.
Well, vacation time.
He wants to
But
keep
off the
an
record,
outer
vacation time, this type of cases come, my lord. So at least whatever.
Honestly,
I'm deeply.